Ready?
Are we live? Good afternoon. Welcome. This is the Rehoboth Beach Planning Commission, our special meeting today. And would the secretary please call the roll?
Commissioner Bryan,
Present.
Commissioner Davis,
Present.
Commissioner Ellison,
Here.
Commissioner Gay,
Here.
Commissioner Hunter,
Here.
Commissioner Stewart,
Here.
Commissioner Stockdale,
Here.
Commissioner Strange,
Here.
and myself. All are present.
Good. I call the meeting to order. It's just after 2 o'clock. If I could, please, I'd like to introduce Mary Ellen Gray. Would you come forward and say hello? Tell us your new
Hello.
position, please.
Sure. Good afternoon, Planning Commissioners. My name is Mary Ellen Gray. I'm the new Planning and Community Development Director here at the City of Rehoboth, and I'm pleased and honored to be here today, and also to be here serving you all and the citizens of the City of Rehoboth.
So you are on board full-time at this?
Yes, sir. My first day was October 23rd.
And I take it you will be assisting the Planning Commission in carrying out our duties?
Well, carrying out your duties, I will certainly be serving as a technical assistance and providing support to the Planning Commission. Yes, sir. Yes.
As well as running the department, the building and
Yes, sir.
licensing.
Yes, sir. Absolutely. Yes. I'll be managing the building and licensing department. Yes.
All right. Does anyone have any questions for Ms. Gray? Welcome, and we look forward to having you here.
Thank you.
Really do.
Thank you very much.
Thank you. First matter on the agenda for today is the continued discussion and possible approval. Well, first of all, Ms. Womack, did you notice today's meeting, as you always do?
Yes, I did. The agenda was posted in City Hall and on the portal on October 25th. It was amended on October 31st and reposted the same day.
Thank you. Our first matter on the agenda, under old business, is continued discussion and possible approval of a report of the Planning Commission in response to that certain resolution of the mayor and commissioners of the City of Rehoboth Beach pursuant to 22 Delaware Code Section 708 concerning a potential alteration, vacation of a portion of Baltimore Avenue at its easterly terminus, which includes the impacts, both positive and negative, of the proposed alteration or vacation. Mr. Mehta. And I believe we have up on the screen now a copy of that document, which is a support document for the agenda of this meeting. And would you walk us through this document, please, Mr. Mehta?
Yes, so good afternoon. So on the portal is a public document, which is a draft report of this commission for the commission's review, consideration, and possible vote, either today or tomorrow, on the referred matter. I'm not going to, it's a public document, I'm not going to read the whole thing. I thought I would just set it up and then direct the commission's attention to the specific draft recommendations in the draft report. If you just go to page, right there, just keep where it is. So the setup is there's a specific referral to this body by the Board of Commissioners, and the relevant language of the September 29, 2023 resolution is that now therefore be it resolved, this is the resolution of the Board of Commissioners, be it resolved by the Commissioners of the City of Rehoboth Beach in session met this 29th day of September, that under 29 Del Code Section 708, the proposed alteration of Baltimore Avenue at its easterly terminus is referred to the City of Rehoboth Beach Planning Commission for report concerning the impacts, both positive and negative, of the proposed alteration. On pages 3 and 4 of the draft report, There is reference to relevant sections of the city charter, the state code, and the city code, which I don't, unless anybody has any questions of, I don't intend to repeat here verbally. The only relevant thing I will point out is that on page 4, the state code section 708 makes it quite clear. This is the scroll up just a second. Whoop, can you go back up? Oh, you're there. Perfect, right there. Thank you. The last underlined section under 708 is that the Planning Commission certainly should respond to the specific referred matter, but the Planning Commission also has the authority, the power by state code, to make a recommendation on related matters, that a matter is related to the referred matter, and that is contained in some of the recommendations. So the first recommendation appears on the top of page 5. First recommendation is bold. So all the recommendations in the draft document are in bold, and the recommendation is underlined and bold. There's a typo there. The first recommendation is the Rehoboth Beach Planning Commission recommends that the Board of Commissioners confirm the following apparent facts. A, that Baltimore Avenue is a city street, and B, that the City of Rehoboth Beach has not adopted an official city map. I think it's quite apparent from the information that was presented to this commission back on October 6th that those two appear to be the case, but it's the Board of Commissioners that will hold a public hearing, and your recommendation may want to include a specific recommendation that the Board of Commissioners confirm that as part of the record that they develop. And Chair, I don't know how you want to proceed. If silence of the commission indicates general consensus or consent. My understanding is that you may or may not be voting on the draft report today. There may be other amendments that are suggested today that you may want to wait with taking any formal vote on any particular recommendation. It's up to you.
That's correct. I'd rather go through all the recommendations, see if there are any supplemental, any augmentation, anything like that. And so let's let each recommendation, unless there is a comment, let's let silence constitute a consent at that point, move to the next recommendation, and then when we get to the end, let's see where we are.
Okay. So assuming there's nothing on that one, then the next recommendation is at the bottom of page 5, which is just shown on the screen. The Rehoboth Beach Planning Commission recommends that the Board of Commissioners obtain and use for reference purposes a clearer, larger, and more legible visual depiction drawing of the proposed abandoned area. It is important that all stakeholders, including members of the Board of Commissioners, are aware of the exact dimensions of the proposed abandoned area, including in relation to the existing street, fixtures, and neighboring properties.
Is there any comment to that? Hearing none. To the next one, please.
The next proposed recommendation is on page 6. Thank you, right there, it's fine. The Rehoboth Beach Planning Commission recommends that the Board of Commissioners obtain and use for reference purposes a clearer, larger, and more legible visual depiction of the precise boundaries and characteristics of the properties immediately adjacent to the proposed abandoned area. Integrated visuals, including photographic representations demonstrating the relationship between the proposed abandoned area and adjacent properties would be helpful, including not just existing buildings and uses, but also proposed future buildings and uses. For example, the proposed One Rehoboth project in respect of, for example, garage entrances, loading berths, and the like. Similar depictions of turning lanes, fire hydrants, emergency generators, and related fuel tanks and other equipment within or near the proposed abandoned area would also be helpful.
I think this was referenced quite a bit at our October meeting. Does anyone have any additional comments to this? All right, next recommendation, please.
Next recommendation is on page 7. Thank you. The next proposed recommendation in the draft report is as follows. The Rehoboth Beach Planning Commission recommends that the Board of Commissioners create a complete record of the public benefits arising from the enhancements to the Rehoboth Beach Patrol structure itself. The views expressed at the Rehoboth Beach Planning Commission's October 6, 2023 public meeting may not be reflective of all public views regarding the positive impacts of the project. The Rehoboth Beach Planning Commission further recommends that the Board of Commissioners seek to establish and/or determine during a subsequent public hearing why the extent of the proposed abandoned area is necessary for the Rehoboth Beach Patrol building improvements. Could the structure's improvements be accomplished with less abandoned street area, especially in view of some of the concerns described below or later, including, for example, fire lanes and other emergency access along Baltimore Avenue toward the boardwalk?
I think that this recommendation is based in large part on Mr. Strange's comments at the last meeting and concerns about safety. And does anyone have any comments, any additional comments about this? All right, sir. Next one, please.
The next proposed recommendation in the draft report is at the bottom of page 8. Thank you. The Rehoboth Beach Planning Commission recommends that the Board of Commissioners create a complete record of the possible negative impacts of the proposed abandoned area. The views expressed during the Rehoboth Beach Planning Commission's October 6, 2023 public meeting may not be reflective of all public views regarding potential negative impacts of the proposed abandonment. It is possible that the city has addressed Mr. Moore's, and that's Chad Moore's. It is possible that the city has addressed Mr. Moore's concerns since the October 6, 2023 Rehoboth Beach Planning Commission meeting. If so, any such arrangements or agreements should, 1, be placed on the record before the Board of Commissioners, and 2, be confirmed in writing and be made available to the public for review.
Any additional comments? All right, that's the last of the recommendations on this exhibit, correct?
No, it carries on.
Okay.
The
ahead.
top of page 9. The next recommendation is on, proposed recommendation is on page 9, top of page 9. In addition to the foregoing recommendations, the Rehoboth Beach Planning Commission also recommends that the Board of Commissioners evaluate and resolve the following issues related to the referral, and there's reference particular to 2 portions of the code that were raised in the October meeting, that is 92-36 regarding parking and fire lanes, and 92-65, which is parking areas for handicapped persons. If you go to the bottom of page 9, please. The proposed recommendation in this draft report is as follows in respect of 92-36. It is possible that compliance with section 92-36 of the code has been addressed by the city since the Rehoboth Beach Planning Commission's October 6, 2023 meeting. If so, that should be made clear on the record before the Board of Commissioners. In any event, the Rehoboth Beach Planning Commission recommends that the Board of Commissioners address specifically, 1, whether section 92-36 of the existing city code will have to be amended to accommodate the proposed abandoned area, and 2, if so, can the necessary code amendments be accomplished without compromising fire safety needs?
Any comments as to that one, please? Mr. Strange, you okay with that? All right. Next, please.
On page 10, and this is the proposed recommendation in the draft report for 92-65. It is possible that compliance with section 92-65 of the code has been addressed by the city since the Rehoboth Beach Planning Commission's October 6, 2023 meeting, including how the proposed handicap parking spaces would accommodate the fire lanes established by section 92-36. In any event, the Rehoboth Beach Planning Commission recommends that the Board of Commissioners address specifically, 1, whether Section 92-65 of the existing city code will have to be amended to accommodate the proposed abandoned area, and 2, if so, can the necessary code amendments be accomplished without compromising appropriate handicap parking access?
Any additional comments? All right, next, please, sir.
The next draft proposal recommendation is on page 11. Thank you, right there. First, the city may want to consider supporting any necessary. Okay, so let me back up here. This relates to the issue that was raised by Sam Cooper regarding whether the proposed abandonment would reduce the frontage along Baltimore Avenue for at least one lot, to less than the code required 50 feet of frontage. So the recommendation is the city may want to consider supporting any necessary variance requested of the property owner regarding loss of frontage along Baltimore Avenue resulting from the proposed abandonment.
Hearing none. Next, are you on page 11 at this
Still on
point?
page 11, the next proposed recommendation. And this has been alluded to more obliquely in prior recommendations, but it's more specific here. The Rehoboth Beach Planning Commission recommends that the Board of Commissioners ensure that any agreements or understandings reached between the city and adjacent property owners related to the proposed abandonment be confirmed in writing.
And I would like to add to that, and made available to the public for review. Any comment as to that? All right. Mr. Mehta.
Then there are two recommendations on the last page, page 12, the first of which reads as follows. This has to do with general infrastructure. The Rehoboth Beach Planning Commission recommends that the Board of Commissioners address whether the proposed abandonment will impact infrastructure, such as sewer lines, stormwater drains, and any underground power lines. The Rehoboth Beach Planning Commission also recommends that the Board of Commissioners evaluate and determine whether the pavers shown in the Davis-Bowen presentation should be pervious in nature.
I have one comment on the sentence, the first sentence dealing with infrastructure. I would propose that we add at the end and possibly impair their proper functioning. I think, that parallels the recommendations that we made about parking and fire line for the handicap and fire line access, and it makes it more clear that we're trying to preserve the integrity and proper functioning of these facilities.
Anyone have any thoughts about that to the contrary? All right, sir.
Well, it says impact, so I would argue that that encompasses, I don't know.
Good and bad?
Yeah, I mean, I think it's a big tent impact that would address, does that address your concern or not?
Well, I made the recommendation because I didn't think it did. I think that our role here is to make sure that the city knows what it's doing, that this abandonment is properly properly sized, and that it won't result in any unacceptable impacts to a variety of public services. And I think it is helpful to direct their attention to the fact we want to make sure that whatever there functions properly. That was a concern, for instance, raised by Mr. Schulman when he referred us to past discussions. He talked about stormwater management and assuring proper functioning of those facilities. And I'm just, at one level, I grant it's sort of making it abundantly clear, but I don't think that's harmful given our role here as a planning commission.
Any other comments? All right, thank you, sir. That's accepted.
In view of Commissioner Stockdale's comment and Mr. Schulman's letter is also on the public record, the commission may want to, which is not in this draft report, may want to consider a possible recommendation to the Board of Commissioners with regard to Mr. Schulman's letter or any other public comments that are reduced to writing.
Well, as to Mr. Schulman's letter, which it was addressed to this body, would suggest that Mr. Schulman forward his letter to the Board of Commissioners. And I would point out that many of his suggestions have already been incorporated into this draft report that we're discussing here today, but I think it would be a good idea for Mr. Schulman to forward his letter to the Board of Commissioners, address it to and forward it to them. All right. What else, sir?
And the final proposed recommendation in this draft report that's publicly available is also on page 12. This has to do with the discussion on whether any zoning designation or classification should be made for a public building. The Rehoboth Beach Planning Commission recommends that the Board of Commissioners consider whether to designate the new Rehoboth Beach Patrol building with a specific zoning classification, such as O1, open space, or simply municipal building.
That would seem to be preferable to having just a blank spot on a zoning map.
Be something, right?
Does anyone have any?
It's no longer a street, it has to be something.
Yes. Does anyone else have any comments about that? All right, Commissioner Davis.
I have a comment and a suggestion. I don't know whether it should be a separate recommendation or incorporated into one of the existing recommendations. But my concern is about notice to stakeholders. We, at our October 6th meeting, heard from representatives of 2 of the 3 contiguous property owners, the Admiral Hotel and 1 Rehoboth Avenue, the proposed hotel. But the Atlantic Sands Hotel is directly across the street, and for whatever reason, they were not represented at our meeting. There was oral.
Speak into the microphone. We're just getting
There was an oral representation that members of city staff had delivered notices up and down Baltimore Avenue to businesses and property owners, although there's no written record of that. And so my recommendation or suggestion would be that the city compile and maintain a record of all communications, notices, contacts with all stakeholders on Baltimore Avenue, not just the contiguous property owners and businesses. And by that, my concern is that I know nobody wants to, in the future, have someone come forward and say that there's a problem directly resulting from this abandonment on Baltimore Avenue, but nobody told me what was going on. Maybe a notice was left by one of the salespeople in my shop, or, one of the hostesses in my restaurant or whatever. But I think it's incumbent on the city to make sure that it has a complete record of who was contacted and when and what the nature of the contact was. And was it a notice, which I think it should be, that all stakeholders were provided with a copy of a document that outlines all the details of this proposed abandonment, and including the positive and negative impacts, which there are references to in some of these recommendations, and that they all are specifically notified of when and what the Board of Commissioners' public hearing is going to be all about, when it's scheduled.
Yes, would that recommendation also include making as part of the record a copy of the notice that they were given and any written responses?
Oh,
that the
absolutely. And I
landowners-
say a record of all communications back and forth.
Good.
Because, I know that there's no specific notice requirements for this public hearing in the city code. But I would hate for it to be a tombstone in the second to the last page of the Cape Gazette, where people who really were concerned about this, it was incumbent upon them to find it and read it and know about it.
Anyone else have any thoughts about that? Is there a
I agree.
any a consensus?
Yes.
All right. Is anyone here today from the public to speak to this matter? Don't be shy. Hearing none, we'll close that section of the meeting. Mr. Mehta, do you think you can put this together?
Yes.
By tomorrow's meeting?
Yes.
Okay, it would be in my intent to ask the commission to vote on this recommendation, tomorrow, this report tomorrow, so that it can be forwarded to the Board of Commissioners.
So we would be adding the comments that were talked about today, the
Yes.
the changes that were talked about today, and then voting
So
on it
yes,
tomorrow. Sorry. We would be, you would be making the minor changes overnight, and we'd be voting on the document then tomorrow.
yes, to ensure maximum public transparency, the idea would be to generate a revised written report that takes into account the oral amendments suggested today, so that you can vote on a new written report tomorrow.
All right.
Mr. Chair?
Yes, sir.
Yeah, I have a general question. It's been bothering me through this whole process. On the original charge from the planning commissioner, it says, "For a report concerning the impacts, both positive and negative, of the proposed alteration."
Yes, sir.
And all we've been able to do is generate questions because the data given to us by the city, by everybody, has been completely insufficient to achieve that goal. So we're giving back them a report that says, here's all the things that should have been done, but weren't done. This doesn't come back to us. This ultimately, whatever happens, the commissioners are going to do their thing and vote on it. Is that understanding correct?
I think that's the way the procedure's outlined. Yes,
After a full public hearing.
correct.
Right, so at this stage, what they've asked for explicitly, we're basically, I almost feel like I want to have an explicit statement that says, you asked us to give you a report concerning the impacts, both positive and negative, and yet we were not given any data by the city, any of the contractors, by anybody, to reach that conclusion. And I find that very disturbing. I may be the only one that has that feeling, but I look at it strictly from the science perspective, and this project is completely lacking in providing sufficient data to draw any conclusion, good or bad. And I'm very disturbed by that.
Yes, I mean, to the extent that our job was to point out the issues, and we are asking for additional information to be presented by the Board of Commissioners to the public and to be considered at a public hearing. Whether or not it would be a better procedure to return it back to us for a further analysis, I don't see that in the code.
Right, it's not in the code, but I feel very badly, though, that they explicitly asked for a report of explicit impacts, positive and negative, and the city themselves did not provide sufficient information to do that. So it's sort of a circular conundrum that I'm very vexed about, very disappointed, quite frankly. Not
So-
with us, but with the city.
So I think,
But would an acceptable compromise be, because I'm thinking that we could point out that we did not have evidence, we were limited by the available evidence and the testimony that was given, and that fact gathering is still ongoing. The point being, I am unclear on what our specific charter would be if we were given more information. You know, we would just basically be spitting it back to them, because to me, it looks like what they're trying to do now is to complete a record. And that's what we're aiding them to do by we're pointing out where there are gaps in the information, where we have information, where concerns were raised, but where we are limited by the fact that the process is not complete yet. In other words, they were still contacting property owners at the time of our last meeting. So yeah, I don't disagree that we should point out that our hands were somewhat tied by the information we have and by the procedural construct that we're laboring under. But I think that's really about as far as we can go, because otherwise, I think we generate this idea of we should do more fact-finding, and if I'm questioning where more fact-finding would lead us, given our function as a planning commission.
Yes, I think another concern might be the 45-day rule that's
Right.
part of this statute, so that it, or ordinance, so that it might negate what we've done so far if we don't issue a report within the 45 days. Now, up to the commissioners as to whether they subsequently want additional information or something of that sort. But I think we'll have done our duty here, albeit with concerns, such as what Mr. Strange has reported. But at least we have fulfilled our statutory obligation at this point. Yes, Mr.
I'll let others talk. Go ahead.
This is exacerbated a little bit because I'm looking at the State Code 708, which says specifically that such planning commission shall have full power to make such investigations, maps, reports, and recommendations related to the topic. So I don't know where that leaves us, but I think that's an important statement as well.
Yes. Yes, Susan.
Well, I concur with Mike's comment, and I said this at the outset of our first meeting, sensing that we did not have the tools to do the investigations, that we have the option of not issuing a report. Because I'm concerned that we're issuing a report, as you say, that is a non-report. And everything in our report is evident now from everything the Board of Commissioners has before that. They have the capacity to have public hearings on this. And, you know, I am concerned exactly about what Mike said. I share that concern.
Yes,
Yeah,
sir.
thank you. I agree we need to issue this with everything that's in there, because it's extremely important. Because this should sensitize the commissioners. One of the things that disturbed me at the meeting, which I looked at the video, there were some commissioners that said, oh, well, this law is essentially obsolete anyway. All right, have them do it to get it out of the way. And it seems like it's CYA, and I don't like that at all.
That was the solicitor, I think, because I looked at the hearing too.
Okay, and I'm very disturbed by that. If anything, the law that was passed 60 years ago is more relevant today than it was then because of the density and the increase within the city itself and the urban form. I'm further discouraged that what was presented to us by the city via the contractors, and I think everyone did this in good faith. I want to make that clear. I don't think anyone got up here, and some of the folks I know personally, were misrepresenting anything. They were indicating everything that they had evaluated and what their conclusions were. But I think the net of that is that the project ended up being a project which was deficient in a multitude of ways, which we've identified here, which we haven't been fully capable of evaluating because we weren't given any of the data to do it. However, having said that, we need to issue this to sensitize the commissioners so they're aware of what the stakes are and the fact that they're making decisions on if they were to make a decision, in our collective opinion, it would be on a series of a lot of missing data on the implications of the future impact of this particular entity for the abandonment of the amount of space that's required. I think the underlying issues go far deeper than what has been observed or presented to the public by the commissioners in their own dialogue or by the various folks within the city's management to their particular pieces of the pie. They're all looking at their specialized area of information. But when you take all those specialized areas and put it together, you end up with a solution which, quite frankly, is far less than optimal and very risky inherently by its structure going forward. And a lot of people don't know these techniques that you use to analyze things like this. But here, so many things were done in silos and then added up and said, okay, here's the project. It has a lot of dimensions that are, from a risk perspective, very bad. And I say that because of my professional expertise in this field. It's problematic. And so I think this document needs to get published. I just hope it's just not taken as, okay, we got it, now let's vote and go forward. And that's a concern that I still have.
If I may, I'd like to go back to
Yes, sir.
where I started. I do agree with everyone that, you know, we were asked to issue a report, and we have been very handicapped by the lack of facts to make specific conclusions about concrete impacts, okay? I favor noting in the report that we have done the best we can given the information that was available to us. I think we should say that. I think we should note that we've issued the report because we were directed to issue the report. And as our chairman has reminded us, there is a timeline associated with our actions here. But going to your point and to yours specifically, I'd like us to reflect on what is the object of making that observation. And I think that the object is that it shouldn't happen again. In other words, if we would have any other circumstance similar to this, we should not be getting it the way we did and with the information we have. So all I'm raising for this body to consider is, if we make those observations and we make the note that we've done the best we could, is your point that we should also include a statement that in the future, should similar circumstances or cases arise, we hope more information would be available to aid this body in making similar recommendations? If that's the case, you know, maybe it would be better to note that rather than just a kind of a generalized complaint about how the handoff was made.
Ms. Davis.
I come at this from a slightly different perspective, not that I disagree with anything that's been said, but the positive impacts of this project, which I agree with Mr. Strange, where Commissioner Strange, when we were presented with it, it was a shovel-ready project. I mean, the planning had been done, decisions had been made, and they were ready to start demolition of the existing building and to get the project going. So, you know, we are rather late into this game. But the positive impacts, I think, are fairly self-evident. We all know that we're going to have a state-of-the-art lifeguard station, which is way overdue, that will have a complete enhanced view of the ocean and all of the things that I think everybody knows. It's certainly been all over the Cape Gazette and the subject of discussion. Perhaps we might put a paragraph in this report to bring it closer to the resolution we were given that would actually identify, summarize, one paragraph could take care of it, the positive implications and points of this project. And I think as far as the negative issues, we've gone a long way toward identifying potential negative issues about which we do not have enough information to know, to follow them through and reach a conclusion as to whether they are negative impacts. but we've at least flagged subject areas and specific issues that need further explanation, at least as far as we're concerned, as to whether they are in fact negative implications. So in some respects, I think we are doing exactly what we were asked to do. The fact that we don't have a paragraph saying all the good things about the project, I'm not sure. I mean, we all know what they are, but that could certainly be included. But I think the main thing is that we have identified a host of potential issues that the public and the city should be aware of in terms of evaluating this project going forward and for the public hearing itself.
If I may just remind the commissioners, I only read the draft recommendations. There's language in the draft report that does summarize the positive and negative aspects of the proposed project, and they're in the draft written report. I just did not read those today. I only read the recommendations.
Mike,
Susan.
so in response to Earl's comment about what do you want to convey, I'd like to convey that the data needs to be gathered by another body, if it's the commissioners or whomever. But these things take time. I mean, even if we set out day one to commission the experts we'd need, I don't think we could have done it in 45 days. Now, I know that's a state statute, so that's not the fault of anyone, but I'd like to convey that there is a need for a fact-based decision on this, and it's not a matter of, is the whole project good and have positive attributes? Is this abandonment necessary? Is it right-sized? Can the fire marshal get in? Can the trucks get in? Does it have handicap spaces? Those are factual things. You know, I think in an odd way, if this had been a project that needed permitting and site plan review, things would have come up earlier.
Right.
But because it didn't need that, we're trying to, we've got the horses, now we're trying to build a barn around them. And that's an unwieldy process. So that's what I'd like to convey to the commissioners, is there are serious deficiencies in data for any body to be able to make this decision.
And hopefully now that the city is apprised of this process, you won't have this last minute hurry up to catch up. But is there support for Susan Stewart's thoughts here?
Yes.
And what do we add? I mean, it sounds like, based on what Mike Strange has said and based on what Earl and Susan have said, that there needs to be some other language in there that we were working with very limited data, and that we recommend that the city complete all of the recommendations before considering, I mean, right?
That could be an additional recommendation.
I mean,
Well, since I'll be drafting this tonight, I want to make, and you're going to be hopefully voting on this tomorrow, I want to make sure that my direction is clear. What I'm hearing, but you're the commission, I'm hearing adding some language in the body of the report to address many of the concerns that have been addressed here today. I don't hear any of that actually altering any of the recommendations per se.
Correct.
But if I'm not reading you right, please let me know.
But perhaps a preamble, not necessarily identified as such, but a lead-in paragraph that says the challenges we face, the dearth of data, that we're passing this on, having what we thought productive conversations about areas of inquiry, but that we don't have, but that these analyses need to be completed.
And I think the point is that we're encouraging them to perfect the record, if you will, to complete the record before a decision is made.
and I think some of that's in here within the individual recommendations, but I take your point, it might be better to have that as a global statement as well. Is that what you're suggesting?
Yes.
Yeah, right.
Mr. Mehta, do you have enough direction?
Yes.
Okay. Good discussion, thank you. Unless there's an objection, we'll move on to the second item. And if we could have the document put up on the screen under 5B, Continued discussion and possible consideration of a recommendation to the Board of Commissioners on revisions to Chapter 236, Subdivision of Land and Site Plan Review.
And, or whoever is controlling the screen, I think it would be more helpful to show the red line document. So not, this is the clean document. There's another, the next document is the red line proposal. There you go. Thank you. So this is a continuation of the Planning Commission's February 2023 recommendations regarding proposed amendments to Chapter 236 primarily. There's also a proposed amendment to Chapter 270, which is a zoning code, arising out of events from last summer that produced a specific referral by the Board of Commissioners in August of 2022, which resulted in the February 2023 recommendation of the Planning Commission. After the February 2023 recommendation of the Planning Commission, there were additional events that occurred, new facts that came before the Planning Commission, and then, of course, there was a voracious work product generated by Wallace Montgomery, which had, as the Commission concluded, many, many good ideas. And so the Board of Commissioners subsequently referred back to the Planning Commission to take another look, a more comprehensive look at proposed changes to Chapter 236 primarily. And so this draft, which is a draft, you're the Commission, you provide the direction. This draft attempts to clean up some of there were some minor typos and other errors in the February 2023 report, add some additional language regarding the independence of this body, and third, to incorporate some of the good ideas recommended by Wallace Montgomery. So that's how we got from August of 2022 to where we are here today. Many of you have indicated that it's far easier for you and for the public to track the proposals if the proposals are shown in red-lined form. So even though there are two documents, one is a clean version. I'm going to work off the clean version, but what is displayed is the proposed red line. So these would be red lines, your proposed red lines, against the current language of the code. This is not a red line against your February 2023 or against anything, or it's not a red line against the Wallace Montgomery report. This proposed red line is a red line against the currently existing code, okay? So I don't know how you want to proceed. I mean, some of this language should seem not new to you because it's contained in your February 2023 report with just some cleanup, but some of it is. Can we just scroll to, excuse me, to the top of this page, please? Ann or whoever is, thank you. So the increase in intensity of usage, that is the same definition that was contained in your February 2023 report. I don't believe there are any changes here. If there are no comments, I'll move on to the next one. Same thing with oceanfront parcel of land. This is a proposed new definition for section 236.3. Of course, this arises directly out of the CDP that was approved. And then we go to site plan. The code currently has a definition of site plan review But the code does not have, and Wallace Montgomery recommended that the Planning Commission add definitions for project concept plan, preliminary site plan review, and final site plan review. And one of you has suggested that we, consistent with other language in the code, break the sub-definitions under site plan into A, B, C, and D. Site plan review generally, project concept plan, preliminary site plan review, and final site plan review. Again, I have not redlined this document against the your prior draft or the Wallace Montgomery report, but you may want to scroll up to A, please, which is site plan review generally, because this will indicate the proposed red line changes against the existing code. Can you scroll up to up one page to for site plan review generally, which is A? There we go. A little bit further. Perfect, thank you. So this shows how this proposed amendment would modify the existing definition of site plan review. The other B, C, and D would be proposed new definitions that you did not have in February, but take into account the recommendations of Wallace Montgomery.
Looking for some direction.
Just if I don't want to. It's a lot of information. I don't want to rush people. But
It's only been a year and a half.
well, some of this language isn't that old. So. All right. Assuming no comment, then we'll move on. If you scroll down to substantial renovation. Yep, thank you, right there. This is the very similar to your recommendation from February of 2023. It just adds under B the phrase "an existing building" at the end. So more than 25% of the gross floor area, we've added "of an existing building" to make it consonant with the first portion of substantial renovation. So that adding "of an existing building" in the third and fourth line is the only modification from your February recommendation. Unless there's anything else, move on to the next section, please. Now, this is a fairly important substantive issue. There are two sections of Chapter 236, 236-28 and 236-34, that discuss public notice and a hearing, either for a subdivision plan and or a site plan. What is recommended here in draft, a draft recommendation by you to the Board of Commissioners, is to clarify that 236-28, which is actually not in Article 7. Article 7 is the site plan review chapter, okay? So the recommendation here is to strike from articles that do not deal directly with site plan review, therefore to strike from 236-28 the reference to site plan reviews in the hearing required and notice, to make it clear that that section 236-28 applies only to subdivision applications.
Just a cleanup of the code language, basically.
That would be the suggestion.
Yeah.
Any concerns?
This issue will come up again at 236-34.
Yes, it's a placeholder for when we talk about 236-34. Okay, moving on then to really the heart of the originally referred matter, which is 236:30, and I suggest that we, I apologize, sometimes doing compare right is not as neat and tidy as you would like, but if you just scroll down a little bit further, just go down to show the, there we go, thank you, that's perfect. So this is redlining against, it's actually, yeah, I think because of the way this red line was done, it was a complete striking of the existing language and a proposed new language. So it's not exactly, this does not actually show the a red line against the existing code because of the way the red line was generated, and I apologize for that. I'm just seeing this now that because the red line program struck the existing 23630A and inserted a new 23630A, it doesn't, I apologize, it doesn't show it as clearly as I had hoped. If you like, I can pull up.
I mean, essentially what struck there is the A, that exists now.
So-
That is what exists now, at the very top.
Yeah, so let me, just give me 1 second, please.
Higher up has got this
Yeah.
stricken language.
Yeah, higher, go up a little bit. Scroll up to the beginning of 23630.
There it is.
See, that's the
Thank you.
existing code.
Yes.
Yeah.
Okay, so
is there.
maybe just the preamble, you can compare the preambles first before getting to,
I mean, the difference is basically listing it all out more clearly than it was all part of a paragraph before, and now it's being listed separately.
correct.
I do have one question about this one that I actually just noticed, or I would have told you about it before. When you scroll down very slightly, where it says for a commercial project, either comprising over 15,000 square feet, B, involving a substantial renovation, or C, involving an increase in intensity of usage. In the original wording, there's an or between A and B, as well as between B and C, which I think ought to be maintained because it's not a project over 15,000 square feet that has a substantial renovation or that involve, it's either or. It's anything over 15,000 or involving a substantial renovation or involving an increase in intensity of usage,
Okay,
right?
Yeah,
I agree.
So
this
there's
is
an or missing.
Add
There's one
or
or
before
missing.
B.
Yeah.
Got it. Again, we have not redlined this against the Wallace-Montgomery recommendation, but I can tell you, and if you go back, you'll see it on your own. Wallace-Montgomery recommended that A1 and 2 be separated out. In your initial February report, you had conflated A1 and A2. Wallace-Montgomery recommended that you separate them out, and that's what is shown here. Wallace-Montgomery also recommended that you add A5, which is a mixed-use project, which may be a very good idea. So that is also new. A5, mixed-use project, is also new compared to your February 2023 recommendation.
Does this point out the need for mixed-use zoning?
No, that's not what this is. This is simply site plan review. Mixed-use zoning may be a topic you want to take up separately, but that's not specifically addressed here.
I understand it's not addressed, but it starts the conversation of what you might need to implement this.
Yes. So unless there's any other discussion on 23630A, we can go to 23630D. And here, where this differs from the current code and differs from your February 2023 recommendation is the insertion of a new D1, which pushes everything else down by 1. So the recommendation is to add a new general purpose of site plan review, D1, guiding the growth and development of the city in accordance with the comprehensive development plan, the city zoning ordinance, chapter 270, into this chapter. Let's just comment on that. We can go to 23630E. And here, here there is some new language, not only to the existing code, but also to the your February 2023 recommendation. So the first and second paragraphs of proposed 23630E have new substantive content, including the first paragraph to make it clear that it's the city proposed to make it clear that the city manager and the building inspector shall determine the content of any applications to be submitted, the number of copies to be provided, and other associated details. The second paragraph proposed here in this iteration of the proposed recommendation really gets at the issue of this body's independence, as to which there was considerable discussion and debate this past summer. So the language here proposed, so this would be new language compared to the existing code, and new language compared to where you were in February of this year. The Planning Commission shall independently review a site plan and determine whether the plan complies with the applicable city laws and regulations, including but not limited to this chapter in 270, and other applicable federal, state, and county laws and regulations, and whether the plan is consistent with the City of Rehoboth Beach Comprehensive Development Plan. In conducting its independent review, the Planning Commission shall consider, but is not obligated to concur with, the comments of the building inspector or any other city department or agency provided to the Planning Commission pursuant to 23632A, which we'll talk about in a second. Other than that, the only other, well, maybe I just pause there if there are any discussion or comments on that new language.
Everyone, of course, was here and is aware of the discussion. I'm not sure we debated. I think it was a discussion. We never really accepted what the proposed policy was. So any objections to this? Okay.
Again, this is a recommendation to the entity that actually passes the laws in the City of Rehoboth. Otherwise, if you scroll down, please, to 23630E 19 and 21, this just cleans up some typos and other errors. I think under 19, if we had seal level rather than sea level, which is kind of amusing but not really appropriate. And then we also, Commissioner Stockdale's suggestion, changed the proposed language in 19 from other environmental considerations to other relevant environmental factors. And there's also some proposed new language, self-evident, in 21. Unless there's any comments or suggestions, we can move to the next section, which is 23631, Project Concept Review. The main difference here is taking the lead, I believe, from the Board of Commissioners, is to make sure that the code is clear. The project concept review shall be mandatory, not discretionary. So currently, it's discretionary. This makes it clear that it changes may to shall under 23631A. It makes it mandatory. The other suggestions are really flow from some of the many good ideas in the work product of Wallace Montgomery to sort of flesh out the guidance to all stakeholders of what is expected for project concept review. So that's set forth in C in particular.
All right, anything else on that?
Then we go to 23632, which is amends A, B, D, E, and F, but not G, H, I, and J. So this is a fairly comprehensive rewrite of 23632, particularly with regard to, as I said, A, B, D, E, and F. This is language that has been publicly posted on the public records, been publicly available, been made available to you.
Did this come from Wallace Montgomery as well, much of this?
This is a draft based on Wallace Montgomery's
That's what I
input.
thought. Because this is not really something we looked at for the February,
This
right?
was,
Correct.
this is new
News, mhm.
to,
Right.
was not contained in February 2023, and it's not contained in the existing code, but is influenced by the Wallace Montgomery recommendations. And there's also, I think, appropriately addresses some of the awkward language in the existing code procedurally about projects
Right.
moving from the building inspector to the planning commission and some of the perceived negative implications of that process. And this is proposed to address those. So unless there's any further comment on that, we can go to 23633. And here you may want to have some discussion. You may recall from day one of way back in the summer of 2022. I'll just speak for myself. I, for one, publicly struggled with the issue of identifying both affirmatively what types of projects the Planning Commission must go to the Planning Commission for site plan review. That's what's set out in 23630A. And at the same time to seek to clarify the opposite end of the inspections. What types of projects are so small, so de minimis, that you do not want to spend your precious time, volunteer time, on site plan reviews. And so we took a stab at that in February 2023. Wallace Montgomery also had some suggestions, and this proposal pretty much goes back to where I think you were in February of 2023. But I will confess, and some of you may have some thoughts on this, that when you do it this way, and I've been clear about this from day one, it is, since we're not perfect draftspeople and we can't anticipate every future scenario, it is possible that you could have a project that falls somewhere between the proactive 23630A and the exemption under 23633B, and that is kind of awkward. So whether you go with this or you just do the proactive thing is something you may want to consider.
Mike, I have some comments.
Yes.
I think that this provision is unnecessary because I think we've spent a lot of time figuring out which attributes and articulating which attributes would trigger site plan review. And sort of by definition, when you do that, if a project doesn't exhibit those attributes, then it doesn't need site plan review. And that's one, sort of a global issue I have with defining this, because by definition, either it's triggered or it's not. Secondly, I question the language about minor structures and renovations otherwise subject to this chapter. I mean, give me an example that would trigger site plan review. And then lastly, there's a phrase in there about something more than 200 square feet in gross floor area. And let's just say hypothetically, we have a project and it's completed and it exceeds far by a substantial amount, having gotten a variance for that. And 5 years later, that project, that same establishment, wants to add a 200 square foot gross floor area that wouldn't need to be reviewed or permitted, or I guess reviewed. It could be permitted. But I think we're asking for trouble, and it doesn't really accomplish anything, that our articulation of the attributes that do trigger, it doesn't do anything for that, and it potentially opens a quagmire.
Okay.
The only, and you may want to, I don't want to put the building inspector on the spot here. It's not fair, and you may want to give the building inspector some more time to think about it, whether he has any thoughts on this. I mean, you got to keep in mind that the current language does exist, so you can see by negative implication, you can see what the current language has with regard to the building inspector may exempt minor structures which are not part of a conditional use special exception, particularly with regard to minor amendments and additions.
I mean,
which
what-
will arguably go more toward amendments to an approved site plan as opposed to whether a project is required to go through site plan review at all. So I think, so I understand the comment, but as we've discussed before, here I would think we have to be very cognizant of the existing language of the code and the purpose of the existing language of the code, even if in theory we agree with the notion that trying to define an exemption for subdivision review is tough to do.
But isn't everything that's not required to go through site plan review not required? I mean, there's a whole body of things that are bigger than these small projects that still don't trigger site plan review. Why do we need a special treatment of the micro end?
Could I just suggest, I don't remember all the considerations that went into this, but if you go back and look at the current 23630A, subsection 5 under that, which is all struck out, if you go back to page 4 of this document that we're on now, and the top of page 4. So preceding the language that we proposed in February and that we are now, tweaking, basically. So under the currently existing language, subsection 5 refers to any other site plan referred to the Planning Commission by the building inspector until, so no building permit shall be issued for blah, blah, blah. 5, any other site plan referred to the Planning Commission by the building inspector until a site plan has been reviewed and finally approved for such project by the Planning Commission. So that's one of the points at which the existing code makes clear that the final approval for a project comes from this commission, all right? The site plan cannot, no building permit can be issued until this commission has decided that it is correct and compliant and has finally approved it. However, the other aspect of that currently existing language is that it refers to other site plans referred by the building inspector. In other words, others not included in those 4 categories. Now, our revision eliminates that, sort of murky, I mean, I don't know what the history of that subsection 5 is, but that subsection 5 refers to plans, not in the previous 4 categories. That the building inspector nonetheless referred here. And so I'm thinking that it is possible that the provision that we're talking about now, the exemption provision, relates to that rather murky aspect of the existing code that we are proposing be eliminated. So it hadn't occurred to me, Susan, until you said this, that it may be, I'd want to think about this, but it may be that the fact that we're eliminating that portion of the existing 23630A suggests that this exemption language isn't as necessary. In other words, if there was this, I apologize for the pejorative term murky, but it just, let me go with it for a minute more. If that didn't exist, then this exemption, doesn't need to exist. I mean, that's one way, I think, to read that. But, I think that's a very good point. I would want to think about that.
Mr. Janus, could I have you earn your pay today? Could you perhaps opine as to this issue?
I was just trying to think, and thank you, Chair. I was just trying to think of a situation that this could apply to. One of the situations I could say would happen, let's just say an existing building of a restaurant use had a dining patio at the rear of the structure, wouldn't be able to be visible from the street, and they wanted then to make that an indoor portion in addition to that restaurant. That would trigger this requirement, I believe. So it would bring forth an application to you to consider that minor revision. That would be a minor renovation, in my opinion. And so, as you said before, all situations can't be codified. And so whatever catch-alls you would prefer to put into that code, I think, obviously is up to the commission here.
Seen this situation before, this fact pattern?
I guess technically, I hate to use this one, but the sandcastle would have been a minor revision as they enclosed their balconies to incorporate into the rooms. So they got rid of their balconies completely to make more room space. Again, there's differing opinions on whether that should have come before this body or not. I will say, though, that that's an example of this particular requirement.
Again, the last thing I want to do is put the words in anybody's mouth. Is just the opposite process for today. But just so I understand what you're saying, so you're positing that there's a scenario that the Planning Commission may want to consider when you have an existing project that's already been approved, clearly a large project that otherwise, if it were to be torn down and redone, would have to go through site plan review. But you have an existing structure, for example, and the proposed project is a small adjustment or modification to a project that otherwise clearly would go through site plan. Is that what you're positing as a scenario that the Planning Commission may want to clarify in this chapter?
Correct. Also, another example would possibly be tenant fit-outs to existing spaces. Some of these rules could trigger a Planning Commission review should you include those particular scenarios. A restaurant transforming into some sort of office space that doesn't require parking, or that scenario, it may trigger a review at the Planning Commission level where not necessarily needed.
Mm-hmm.
So be careful on the types of projects that you consider.
And just to make sure I know we can't cover all bases,
Right.
but, I'm sorry. You wanna go ahead? I know we can't possibly cover every scenario that might come around, but I guess this definition for substantial renovation is new here and presumably put here to try to help us define things. But you just mentioned something. You just said that the sandcastle had enclosed the balconies and to make more. So would that not fall under the category of requiring the demolition or reconstruction of more than 25% of the gross floor area?
It probably would. But again, that definition hasn't been approved yet, but
Right, I understand, but-
according to this one, yes.
It would have, okay.
Right.
And I'm a little confused because I thought what you were saying is, like, the major thrust of this is to exempt things from review. But you're saying, I think you're coming from a different perspective. Am I correct? You're saying there are things, so it's not so much do we need an exemption clause as a matter of there may be some things that we want to review. I don't know if I'm saying this right. Am I misunderstanding? I'm having a hard time because this is exempting. And my position is if it's not non-exempt, then it's exempt.
No, I think you are correct as a matter of interpreting a
But
statute.
this is a different issue,
But
I
what-
think.
But I think what the building inspector is raising is also an issue that we have been, I think, struggling with for a while is, are there, your time is precious. It's very expensive for the regulated community to go through the whole site plan
Sure.
review process. Is there a category of minor projects, minor modifications, minor alterations to an existing project that are de minimis enough that you want to clarify don't need to go through the site plan review process? And we've gone back and forth on this. At one point, we included this exemption language, not here in 23633B, but we actually added it to the end of 23630A, and we said, provided, however, that the following shall not be required for site plan review. It is a fair point to debate. And it's-
My
Point-
que-
Yeah, okay, well, but if it's not required, then it's exempted. Why
I
do we
think
need
you-
a subset of exempted, is my question.
Well, so
Okay.
again, I want to be neutral, but play theoretical devil's advocate here. So,
Is the problem in the use of the words shall and may in the sentence? In other words, one view would be you're subject to a review, and if you are subject, you are. You don't have to say what's not subject to the review. Here, this starts out like it's saying certain things are exempted, but the exemption is sort of a qualified exemption because it is dependent upon a discretionary determination by the building inspector.
right, and I think there was quite a bit of discussion about, including the building inspector's request, as I recall, I don't want to put words in your mouth, about taking that discretion away so that what is required for site plan review is clear to all, it's objective, not subjective, and it is clear to all the stakeholders. With all due respect, to me, the issue is not so much in the language of 23633, but in there's quite broad language in 23630A, a project involving 1, 2, 3, 4, 5, and 6. And as I understand what the building inspector is suggesting is that there may be, in theory, modifications, small modifications, that if you simply apply the language as proposed of 23633A, may not capture what you really want to spend your time on. So in other words, you can have a modification that involves 4 or more dwelling units, or a modification of 4 or more hotel rooms, or so on and so forth. And if it's small enough, this is your clean slate to make whatever recommendation you want to make to the Board of Commissioners. But can you articulate a category of modifications, I think is really what we're talking about, to an existing structure that you don't want to spend your time on, or not?
The ones not listed, the ones, I'm sorry, I'm
Well-
going to the same thing.
Well, I don't think we are, if I may suggest, because again, can we move up to 23630A, please, on the red line? if you consider what the building inspector is suggesting against the proposed language of 23630A, in theory,
23630.
A.
Can we go to 23630?
page 5,
Page 5 of the PDF.
oh wait, I'm sorry, I'm working off my clean version, so that's not correct.
Page 40 on the,
Sorry. Yeah. Yeah, keep going up again. That's 23631. You want to 23630A.
yeah, 30A.
Keep going up. Up. There you go, right there.
There it is, there it is.
A 1 through 6, perfect. So I would encourage you to again consider, given the broad language here, if there were, let's say you have an existing structure that otherwise has gone through site plan review, been approved, done, ditto. A year later, the owner of that property, as to which has been an approved site plan, wants to do a modification to that document, to that structure, building, project, but it's de minimis or minor. Do you want to capture that in the code language and say, yeah, for those minor modifications, we don't really want to go through the process, or do you not want to deal with it? That's really the issue. Because because right now, minor modification would, I think, be captured by 23630A.
But it's a new project. I'm sorry, it's a new project, correct? It doesn't matter that it went through site and the project was completed.
Let's assume
You're
it's a new
saying once
project.
a building is captured in this forever, it then, taking on a new renovation is still subject to this?
Of 200 square feet or more is what that code requirement was.
And this one is, and then the new substantial renovation is 25% or more of the gross floor area. So for instance, and it doesn't even have to be a new hotel that was approved by site plan review, it could be one that existed for 50 years, but if the entire place was being renovated, if the entire hotel was being renovated, no, not like the same, just interior only renovation, that would be more than 25% of the gross floor area.
Here's a fine example, which I continue to bring up. Number 2, 4 or more hotel or motel
Yeah,
rooms.
that's what I'm saying, yeah.
Switching out vanities of 4 or more rooms
Yeah,
could technically require a planning commission meeting.
right.
So just think about that. That's,
Yeah.
They would need a building permit for that?
absolutely.
Oh,
Yeah, absolutely.
A building permit, but not.
Yes, ma'am. According to this code, though, you would need approval from this body to do that, because it would involve 4 or more hotel rooms. So if let's just say the Henlopen Hotel would like to switch out their vanities or paint all their rooms, it could potentially trigger this requirement.
Well, that would be, it would have to be under substantial renovation.
It doesn't say that in this part.
Right.
I'm, Commissioner, I'm not sure I agree, because 23630A 1 through 6 is in the disjunctive, separated by or. So if a project meets any one of these things
Yeah,
that we
yeah,
require,
yeah,
and the substantial renovation language is only proposed for 4,
Right.
so I think this is why, imperfect as it was, and maybe is, we, back in February 2023, and still here, are trying to grapple with the notion of this de minimis exemption category, even if it's not perfect.
No, it never occurred to me that we weren't talking about new hotel rooms or new residential units in 23630A 1 and 2.
Well, but it does say no building permit shall be issued, and building permits have to be issued for those kinds of change-outs.
Okay, can I ask a question then, the building inspector? So, let's say the hotel wants to swap out their vanities. Are you saying that that exemption clause allows them to do that as written now, or would allow you to divert that and not?
I would say technically no. It would tally more than 200 square feet if you were to combine
All the vanities?
All of the vanities together, it would be a certain square footage of 80 rooms or more. I'm just throwing out numbers, you know, obviously just not knowing certain calculations, but certainly could trigger those requirements to come forward to you.
Has that ever come up?
The Henlopen Hotel did switch out vanities. That was probably maybe 2 to 3 years ago. It was right around COVID time.
Did it come up?
It wouldn't have triggered, no, because of the current rules. The rules that you're proposing to change are going to trigger that.
And what would have not triggered it with the current rules?
I believe it's the last sentence, anything,
No larger than the existing structure?
right.
Okay. I just want, yeah, okay.
Yeah, because everything was occurring inside, so
Right, right,
you would
right.
have never seen any changes
Right,
to
right.
that.
But I just want to be clear on one thing, and that is they are exempted only if the building inspector makes that determination. Otherwise, they come to us, right?
That is correct. But the language is what gets me in trouble, because that leaves it to my discretion. And as we know, you know, discretion has placed certain individuals into a certain light.
At one point earlier in the process, I hate to bring back history from a year and a half ago now, but we did have a proposed definition, just like we have substantial renovation, we had proposed minor renovation, which would be exempt, particularly going at renovations, as opposed to a de minimis exemption. I think we had a proposed definition for, just like we have substantial renovation, I think we had a proposed definition for a minor renovation, such that a minor renovation of an existing project would be exempt as defined by minor renovation. We may want to go back to considering that.
Isn't that what, excuse me, 270-33B, is that exemption for a minor renovation?
236-33.
236-33.
Right, and so that's why it is in here. That this discussion started by saying, gee, do we really need to have an exemption? Can't we just proactively say what you want to do? But yes, I think 236-33B captures, basically attempts to capture the definition of minor renovation, correct?
But I'm sorry, I hate to prolong this, but I don't understand why the hotel renovations in the Henlopen or any place else would not have been exempt, if you will, or let's just say not covered by 236-30A4, because that would not rise to the level, as you described it, as a substantial renovation.
I think because each of these, any one of these, A1, 2, 3, 4, 5, or 6, would independently trigger site plan review as currently drafted.
So anytime you had 4 or more hotel rooms that you did anything to, that comes for site plan review?
That, the existing language and as currently proposed, unless you change it.
The current
Because
proposed.
I am just obviously very surprised, because I thought in all cases, we were talking about, for example, a hotel project where they're renovating and adding to it, and they're adding 4 or more hotel rooms, or a residential project that involves 4 or more separate units. I thought that these were new or additional hotel or motel rooms, not,
Not changing out
amenities
appliances.
in existing hotel rooms.
Yeah. I mean, it's, it's, I think something like, I note that in our proposed language, subsection 4 of 236-30A includes or be involving a substantial renovation. if or involving a substantial renovation were added to 1 and 2, for example, and it's actually there in 3 as well. 5 is brand new, and 6 says or substantial renovation. I mean, I have the same view that Julie does. I think that, none of us assumed that, vanities would fall within any reasonable construction of the phrase major renovation, but that language could be added to 1 and 2, and maybe that would.
Yeah, I mean,
that would be
that's a
it.
creative way of
Yeah.
addressing the same issue.
Yeah, I mean,
That would address
I'm happy with
Commissioner
that.
Stewart's approach. So,
Yeah.
just, because I don't want to go back tonight and listen to this again. So, so you're suggesting that we add
we had
substantial renovation, the concept of substantial renovation to A1 and A2.
and A5. I mean, if we're going to be complete, because it's already there in 3, 4, and
Could
6.
put it in the lead-in language before the colon, involves substantial renovation of any of these following.
Well,
Okay, well, if you want, or add them to
I
each one.
I would suggest that you be specific as to each of the 6.
Yeah. I mean, yes, I think our, in the various versions of this language, that's why the example, I think, would have to be the 4 or more dwelling units or hotel rooms for there to be any claim that the substitution of vanities would constitute it. So let's just put substantial renovation in those 3 subcategories.
1, 2,
And 5.
and 5?
Well, 5 is new as of this draft, but if we're
Well, it's a
having
new
to add-
category for this draft, but
It's a
it's
new
not, but there
right.
are existing structures.
No, right, I understand, but
Yeah.
for this draft, in terms of the language being new.
For consistency.
Yes, for consistency, so that we're making clear that we are saying what we're meaning.
So are you saying it would be 4 or more dwelling units or substantial
Renovation thereof.
Yes.
Well, that's not, since I'm drafting, I want to be clear. I understand it's a substantial renovation of 4 or more dwelling units.
No, or new construction.
Or new or substantial. Right.
Or new hotel rooms or substantial renovation thereof.
And it needs to qualify mixed-use project as well, or else the vanities in the mixed-use project will get triggered by this. So it needs to qualify that,
New
too.
or additional, I think. is what
Or substantial new additional or substantial renovation of. Mike?
Yeah, I think if, maybe we go back to the basic definition of what Webster says substantial means. It says of considerable importance, size, or worth. And 4 vanities aren't considerable size or worth in the context of anything within a room. So I think the common language interpretation should hold the day on this
Well,
situation.
I mean, substantial renovation in the existing code right now, and what previously applied, substantial renovation wasn't defined. I agree with you that that would be the common sense interpretation of it. But our, one thing that we have anticipated is defining substantial renovation, which makes sense, which makes clear that 4 more vanities would not be covered.
So
Now, can
am
we
I,
talk exemptions?
so that's,
Because
so
the
that's,
building inspector said they wouldn't be caught up, they wouldn't hit that universe of things he could exempt for. And it doesn't seem it's needed anymore if it's not getting caught up inadvertently through the others. Is that a fair?
I think I would agree with that.
Yeah.
what I'm hearing, if I'm going to be the scrivener, what I'm hearing is the building inspector continues not to want to make discretionary referrals to the planning commission, and you're still okay with that. And rather than having an exemption category in 236-33B, we would simply add proactively this concept of new or substantial renovation of the existing under A1, 2, and 5. New, additional, or substantial renovation.
And I'd just like
Janice,
to add, I'm sorry, Chair.
Does that work?
Yes, yeah. I'd just like to add, Chair, that I know my example is absurd, all right? I know it is, but technically it falls under the requirements of those code language, and I just want you to think on those levels.
Good to have those examples.
Thank you.
It's our reality with the absurd, so
It
we're
is.
happy to hear about it.
It's off the table.
Are we at,
Okay, moving on now. That took a little bit longer than the others.
So we're going up to 236.
236-34 now, as proposed here, and you may want to think about it and discuss it and direct the scrivener otherwise. Just as we discussed that 236-28 should only apply to subdivisions, not site plans. The existing language under 236-34 requires the formal 15-day publication notice, not just for final site plans, but also review, but also preliminary site plan review. So the question presented, as to which I have no particular view, it's your recommendation to the Board of Commissioners. Do you, the current language does require this 15-day publication notice, even for preliminary reviews. Do you want to suggest that that is still the case, or that a 15-day publication notice should only be required for a final hearing on site plan review?
Ms. Womack?
I would like to suggest that it stays the way that it is. It's a lot easier for me to remember that it falls in line with subdivision and the Board of Adjustment and Parks and Shade Tree. That's how I do all the mailings. And preliminary review, if it's just segregated for site plan review, it's too much to have to remember. If everything is on board the same way, it's a lot easier.
Well, it reduces the chance of something won't get done.
Yes.
And it was specifically passed in an ordinance 2 years ago that it would be added. So I think it's something the commissioners obviously wanted to do, if it was just added 2 years ago, so.
So this red line was simply intended to surface the issue for your discussion.
So then we would just add preliminary
Yes.
review to the sections here, okay?
Okay. Any objections to that?
I just have a minor grammatical thing in subsection B in the fourth line. It refers to city property owners, and the word whose is crossed out, and who boundaries are with. So I'm
Thank
not sure
you.
what that should be, but not who.
Yes, ma'am.
Who
Ms.
have
Ms.
boundaries.
Womack?
Yeah.
So subsection B, I noticed in, let's see, section 236-27, where it deals with subdivisions, all of the language needs to stay the same. It's different. For instance, for at least 15 days notice of the time and place of preliminary review public hearing on application shall be sent to all property owners whose boundaries are within 200 feet of the boundaries of the property which is the subject of the subdivision application. Such notice shall be sent by certified United States mail to the last known address. We only send certified mail to the subject property owner. First class mail goes to all the properties within 200 feet. And my suggestion is for 236-34 that it should be written up the same way.
So just,
We do certified to the subject property owner, and then first class mail to the properties within 200 feet.
so regardless of the current language is what I understand you're saying, which makes total sense to me, by the way, that the language in 23628 in terms of the notice requirements be identical to the language in 23634 for notice for site plan reviews.
Yeah, but in both, well, 23628, it's listed that it's certified United States mail, but it does not do, you can't determine if that's to 200 properties within 200 feet, or if it's just the subject property. So that needs to be clarified.
I'm not.
23628. And then also in 23634, it needs to be added that certified mail is sent to the subject property owner, and first-class mail is sent to the property owners within 200 feet.
Ms. Womack, do you mind putting that in writing for us?
I sure can.
I mean, since you're the one dealing with it, Ms. Womack, it's a point very well taken. I think it would be helpful to, I think consistency makes sense. And since you deal with the reality of the notice, I think if you don't mind, I think that's a great request.
And Mr. Mehta, if you would put Ms. Womack on the distribution list, please. So she has a chance to look over the product.
And then one last thing.
Yes, ma'am. We're going to have to ask you to come up and sit here, Ms. Womack.
23634C.
Yeah.
It says furthermore, the city manager shall post notice of public hearing. That's done by building and licensing, not by the city manager.
So this was picked up, I guess, from existing code, right? That's what's in the existing code, I think,
So-
maybe. But, yeah,
I think
yeah.
I don't want to speak on behalf of the planning, but I certainly be more than happy to receive your input.
Okay.
Yeah, I mean, the current code says the city manager shall cause to be posted. And the new language says the city manager shall post, so that's the difference.
All right, anything else?
Then the final, you go to 23636, there's a new section on fees. This is almost entirely, it's currently very minor, and it's entirely rewritten, again, based largely on the recommendations of Wallace Montgomery.
Yep.
And then the final section, and this is, again, a vestige from the February recommendation, is the proposed language for inserting 27084 relating to the posting on the city's website, building permits.
Any discussion about that item? Mr. Janice, do you have any thoughts on that?
Again, I think I would just caution you, as my example was the absurdity of the vanities and potentially the 200-foot reclamation of an outdoor dining patio to interior space. Just think about that. Those are some examples that might not necessarily need for you to view, but if you certainly wish to bring those requirements into the code, you know, that is your view.
Do you see any problem with the timing of it?
5 days could be a little stringent.
That's what I was wondering.
It possibly could be, given vacations, time away for training, other instances, possibly, you know, medical issues or anything like that.
How about just 10 days?
10, I think 10 days and not business days would be great.
Then, am I correct that this doesn't necessarily, this is different than things that are just known to trigger site plans? So these are just all?
It's in the zoning code, not the
So it's
site
just
plan.
a function of posting it as opposed to making a judgment of whether it needs site plan review? So if it's commercial or mixed use, it is what this was referring to?
Right, so this assumes all commercial. I would think maybe some verbiage to add that triggers site plan review, unless you want to see all commercial projects come in.
I think we do.
I think the problem that we had, the issue we had in the past was building permits being issued for projects that did not go through site plan review. And there's only 28 days to appeal a building permit. And, you know, I don't object to 10 days, and I understand the issue, but that's 10 days into the 28-day appeal time. So if we're giving notice, not just to the planning commission, you know, city commissioners, board of adjustments, whatever, but also the public, who some members of whom do control your website.
Sure, sure.
This is just an application, though. This is 10 days of receiving the
Oh, okay. I don't have the copy in front of me.
Oh, okay, then a 45-day delay before.
Prior
Okay.
to issuing, yeah.
I think the answer is yes, we do want those. That's straight up.
Okay, so that would remain, this language would be in effect with the exception of making 10 days instead of 5 business days. Is that correct? Okay.
And that is the extent of the draft proposed written language for amendments to Chapter 236 and 270
I'm
for today.
disappointed, Mr. Meadow. I was hoping we could drag this out until at least 4:30.
I will endeavor to make as many, if not all of these changes before you meet tomorrow.
Seem like a lot of changes. So then the next step would be going over those changes and voting on this as well, potentially, right?
Theoretically, you also have another item on your agenda for
Right, we do.
tomorrow,
Yes,
which
we
is
do
the
indeed.
413,
Yes, right.
417
Yeah, so
project
we
concept.
could-
review.
we
Mr.
could
Forrest,
defer this.
he's just here a day early.
I mean, if-
Mr. Robertson.
Robertson, sorry. Sorry.
Do we, we're going to have to, are you going to have to read into the record all of our report that's getting amended and all of this?
So with regard to the report, I will make it clear what the changes to the report are, and that will be read in. But I think, given some of the temporal exigencies, I think my recommendation is that you want to vote on the report tomorrow.
Like, can we waive reading? Can we all individually read your report and attest that we've read it and then waive the reading so we can get to other things?
Well, there's also a public element to it, so I think it needs to be, I mean, I can share with you early tomorrow morning. I think.
Well, you're not going to read the whole thing anyway, right?
No.
Okay.
Just
yeah.
Chairman,
Just-
but I do think we should, at a minimum, read publicly tomorrow the changes to the report.
Yes. Yes, sir. That's all right.
That's all
Called you by the wrong name. You
Yeah,
can,
no, it's
you
fine.
can
I was
talk
just
as long
kidding.
as you want.
Mr. Forreston is my colleague, so. No, and I'm not here, I don't represent anybody on this, it's just me as a property owner. But I also deal with this stuff, you know, people come to me because they want to know what the code says. But it occurs to me and I like the discussion the way it was going, keep in mind that, you know, we're talking about the big hotels, some of which, you know, I'm working with, Mr. Forreston's working with, but it also pulls in small business owners as well. And we know from what I and other people and Mr. Janice is dealing with, that from the time you apply for site plan till you get a public hearing is many months. And that's not because of the planning commission, that's because of the car wash it has to go through. It has to go through Mr. Janice, has to go through Wallace Montgomery, then it has to come to you. And I would add that you all are adding more that you're going to see. We've added back in the administrative separation of lots, back to your jurisdiction. We've added mandatory concept review. So that means there's now 3 meetings on any one application. We've got one Matt Janis who's doing commercial plan reviews. We've got Ms. Gray who's now running the office. I don't know what she's going to be doing plan review wise. But think about like Ava's Pizza, or maybe like the Pickled Pig that was Cuvée Ray. I know those because I did the permit of compliance for those and liquor license things. Between Pickled Pig or whatever, Pig and Fish or whatever it was, Pig and Fish, yeah. Between that and Cuvée Ray, they got in there and realized that the floor was completely rotted. So they had to do a demolition permit and reconstruction, which would have been a building permit through Matt, which I think would have triggered the site plan review, which would have then put the landlord without a tenant for probably a year, the way things are going, and would have put a small business owner out of business for about a year and all those people that they employ. I'm using that as a past example because it's not an absurd one. That's a real one. And I think of Ava's Pizza when that was the seafood place before. Jake's, yeah. You know, whenever a new restaurant comes in, and they're both good. I like Ava's a whole lot. But I'll just use that as an example. You know, they have to do, if they want to change the concept of the renovation, that's going to be a substantial change, demolition permit that's going to exceed that substantial renovation or construction definition that's going to trigger a building permit, a demolition permit from Matt, which is going to throw them into site plan review. And there's probably a host of other circumstances that would fall under that category. Just keep that in mind. I'm not speaking for any small business, but there's plenty of them. And I don't want, as a property owner, Rehoboth to start to deteriorate because people are just living with old building stock and old facades and old interiors, or not improving their small business or getting a better small business in, because that affects all of us. If that starts happening, then all of our property values potentially start going down. And I just don't want to see that happen. So anyhow, just food for thought in this whole process. Just keep that in the back of your mind, that we're actually impacting real people that are owning real small businesses, or maybe the real estate owners of where those small businesses are going, not to mention the employees. So.
May I ask a question, Mr. Chairman? So is it the definition of substantial renovation that would, you think would have caught Cuvée Ray's?
I think so.
Or is it one of the other, like, I'm interested if that's the case, where,
Well,
what would
Cuvée
snag it?
Ray, if you went by the 6 items or 5 items that triggered site plan review, it wouldn't fall under any of those because it was
Right.
too small, I think,
Right.
given the lot size and everything else. But the substantial renovation that talks about 25% of the gross floor area, they literally ripped out the floor, you know? So in that case, that would have triggered it, you know?
And the clause that exempted it in the past was the one that said no larger than the existing building. That was one of the,
Yeah, and I think there was also just sort of an understanding, code or not, frankly, that was just a building permit. You know, you weren't changing the 4 walls of the building
Right.
or whatever. And
Because it would be good to
yeah,
try
I
to
mean,
incorporate that.
yeah, I just think about that. And we, you know, and also small renovations on smaller businesses, you know, we want people to invest in their properties, and we don't want them to think, well, I'm not going to do that because I'm going to lose a whole season if I have to go through a process. That's all. So I would also add, and Ann's going to throttle me for this, but she's giving me the stink eye already. The public notice on the preliminary hearing, and I'm not saying this to try to eliminate public participation, but if you have the public notice and it's 15 days and everything else, that really hinders flexibility. You know, like if you have a concept review and it's something that just greases through and you want to get it on the next meeting, if you've got to do that for preliminary review, and now that we're making concept review permanent, you know, you're going to be 2 months out probably by the time that those legal notices get mailed and Ann takes care of that.
well, we were going to take that out. until we discovered that 2 years ago, the commissioners specifically passed an ordinance within the whereas clauses. It says we want to
no,
add
I'm
preliminary review, so it's.
right there with you. Yeah, I just because we know we're going to have it. Well, everything's posted, everything anyway. Online and the agenda's posted, and the Civic Web's great. So that's all there through the agenda, and everything's embedded. And we're not depriving the public, because you're going to still have that public hearing, the next step. Anyhow, just to think about. I understand what Ann's saying, because consistency is better that way if everything's the same. But it seems like if we're adding more and we want to have sort of a vibrant discussion on each step, that's going to prolong this. And the more we prolong one application, that everybody else falls behind it later on. So, I mean, I can tell you, I'm dealing with this at the county level. For you all don't know, I'm one of the county attorneys, and we have at the county a way bigger staff than one person, and we're running a year behind now. Just trying to get all through the pipeline. Because I'm going to speak for Matt. He's got to prepare for these meetings. He's also got to deal with all the commercial building permits that come through. It's fine that you add the building permits on the website. You'll be surprised what you get, because that's everything from awnings to toilets to building a brand new building. I mean, there's an extent of what people are looking for. It's probably gonna get lost in the shuffle. But think about, you got one person doing all that and then having to prepare for all these meetings and everything else. So that's another big umbrella. Remember the small business, the small property owner that wants to keep functioning and employing people. So. Did I make it to 4? No, I can talk for another half hour.
You could talk slowly.
I just wanted to ask, do you think one of the approaches we've taken is to require simply posting information that's already required to be submitted? And other aspects of it, I think we've made clear repeatedly that we're not interested in the smaller commercial projects. So we're obviously trying to navigate this, because in the past we have been blindsided.
Yeah.
And that has been a big problem.
Yeah, no, and I'm not going to try to wordsmith it here. That's Mr. Meta can help you do that, and it's not going to be easy. But I think you have to be very clear what you want to capture and what you don't want to capture, because to use that word earlier, if it's murky, we know just the way the city is right now. If there's discretion left to Matt, in fairness to him, he's going to err on the side of caution and send it to you all. It ought to be more clear of what doesn't go to you all. Not because I'm trying to exclude you from things that you should see, but I don't want things that you don't need to see that are just building and licensing related to have to funnel their way in here that holds them up and holds everybody else that legitimately should be here. So just the point being, however you do that, just be clear on that.
Yeah. I just want to make clear that our concern is not capturing more smaller projects, but capturing larger projects that in fact have not been captured before.
Yeah, and I agree with that, and I get that from your conversation. I understand that that's what you're trying to do. Just make sure, and however it's worded, that you do, because all 15 of us may not, be where we are in 5 years or whatever, and we're dealing with a different building and licensing person, different me, different you, whoever, and they're going to scratch their head and say, well, this is what the code says. I think it needs to go to the Planning Commission. So I agree with you. I just think we'd just be very clear on that, because I don't think it's quite that clear the way it's worded, and it would potentially capture some of those examples we talked
Well, we could defer the concept review that you have for tomorrow and continue this.
Well, you have a FOIA problem with that, so I'm in.
I have a question of
Yes.
Luke. Is there a provision that allows us to not take up something, if something gets caught up in this and it comes through, do we have discretion to say we do not believe this requires site plan review?
So my recollection, which is not perfect anymore, but used to be, but not anymore. My recollection is that we earlier in this drafting process actually had that language in there that we would then have the discretion to decline, and we took that out.
Because that might be the most effective way to deal with this, because we don't want to review a floor replacement, and that could be handled quickly, especially if we're seeing the projects come through. That would make everyone's life easier.
But don't we have to do that in the context of a public meeting?
Yes.
We do?
Well, yes, but, I mean, it wouldn't delay, it would, so 30-day, it might delay it 30 days, I guess.
Yeah, but then
And-
that's all true, but it seems to me that you're almost putting on a whole public hearing to prove that you don't need to have a public hearing.
It wouldn't be a public hearing, it'd just be a public meeting.
Well, no, yeah, but you would be asking, is this something that we as a planning commission need to see? And so, I mean, it's a public meeting, but somebody's gonna have to present a case as to what it is and why it is or is not something that the planning commission
Well,
could need to
wouldn't
see.
we be able to come to at least a preliminary conclusion during concept plan review?
Well, no,
mean,
you're
that
talking
would-
about things that wouldn't even go to concept plan.
Well, there might not, but I think it would be useful to get the property owner in and explain
Okay,
and get
that's-
on the
that's what I
record
was saying.
what the contours of the project are, and then decide in concept review, or as part of that, or maybe the comments, that this was simply not a project that we needed to spend time in preliminary review, public hearing,
But I don't think
final
that's what
site
Susan
plan.
was saying. I think she's saying, based on our getting a report of applications that have been filed, and Matt perhaps explaining the parameters to us, could we exempt some, isn't that what the language that was previously in the draft?
I'd have to go back and,
Yeah.
and look at that language.
Why don't we
I think
just not take it up?
Right.
well, no, I
think
want to
we're
think,
talking
it's
about-
it's mandatory, the planning commission shall review. But again, this whole process, we've said from day one, subject to what the Board of Commissioners does, every city does this differently. How this city defines the scope of what projects you all want to spend your time on site plan review and what you don't, it's kind of a clean slate. There's no real statutory guidance other than what you want your city to look like and how you spend your time. So, I think, site plan review is mandatory. You could, I'll try to dig up the language we had
I know,
before, but
just so-
you could build it back in. But I do think you want to have it, my suggestion would be that you have at least some reliable record upon which you're exercising your discretion to kick it back out.
Okay, so might we then instead consider language? It seems like we're talking about interior renovations that don't change the footprint of the building. Would that seem to take care of most of the issues? Because we don't want to see vanities, and I don't know that we would have wanted to see the pig and fish cuvee ray floor replacement. Do you feel that way? Can we state that?
I think what we're talking about is a tiny number of possible problems, frankly. And that we, I mean, as we have now added substantial renovation to all of the subparts of 30, that eliminates the vanities and would eliminate some of these. So I do think it makes sense. I mean, we've always wanted to eliminate, consideration of truly minor projects. But the question is, what is a truly minor project? If the sandcastle tears up its entire floor, that is not a truly minor project. Not even to mention the demolition permit issue. But so the question is, I think having some mechanism after we, use the best language we can think of, to have some mechanism that allows for elimination basically of something that we haven't thought of, that can get it, not have it go through a complete site plan review process. But there are many points at which, including now that the commission has asked us to make concept plan mandatory, to cut it off at an early stage. I think it's right that we don't want to see these things, but I also think that is not the problem we've had in the past, and that's not the problem we're trying to fix, and it's not the reason that we were asked to look at 236.
Yeah, and I understand that. You and I are in agreement with that. I just don't want to the unintentional consequences of
Yes,
it
I
that we
understand.
pull those in.
That's right.
Because I think everybody just sort of knew before that that sort of thing wouldn't trigger it, you know, but now there's a much,
Yeah, because we're defining substantial
Yeah.
renovation as more than 25%, and the examples you gave of those two restaurants were more than 25%.
and and it may be just, sorry.
No, you
just
go
a
ahead,
minute. No, and maybe you all touched on it, thinking just dealing with this elsewhere is you know, at some point, I don't know that there's that much of a concern about interior renovations at all, you know? Let's
That's
just
what I
make it
was getting at.
25% on the
Right.
exterior or something like that. Anyway,
I think,
sorry, I kicked the hornet's nest. So, but
yes.
I don't know, just trying to
Mr.
be
Strange.
helpful.
I think Vince's observations, I think, are very well taken, and I think, having observed Sussex County for the last 45 years, your earlier comment about making changes that may catch some of the little fish that aren't intended, in Sussex County, and I'll phrase this because it's outside of our jurisdiction, the big fish have taken immense prerogative with what was intended for the little fish. And it's resulted in ungodly things. And so I think that's the issue that Sussex County, as an example, is playing catch-up on, trying to make it so the little fish get what they deserve, but the big fish don't take advantage of all those little rules and regulations that have been bastardized, for lack of a better term. And I think in Rehoboth, we're trying to find a balance that does exactly that, so that the big guys do what they're supposed to do, and the little folks don't get caught up when someone has a small property or a small restaurant or whatever it may be, a retail shop says, holy cow, I have to do that? But I'm only, X amount of feet. I think we're getting very close to that with what we've done, so the little people don't get caught up in that. But I think what we've done, in the best of my estimation, is we've done it in such a way so that large companies and organizations can't take advantage, I don't want to call it loopholes, take care of benefits that aren't intended for them. It's intended for these other individuals.
And I would just point out, I agree with everything everybody's saying, and I think you are getting close, is that sort of the real life way it works is that, somebody who owns a business or owns a property, their first point of contact, their interface for the city is Matt, and because you can have meetings with Matt and city staff and Mr. Mehta and myself and Glenn or whoever, and then okay, this is the path forward. And if he knows what the rules are pretty clearly, or as close as you all can make them, then he's going to be able to give solid direction to that person. If we didn't have to deal with FOIA and we could have that same meeting with you all and just have a conversation, it would be super smooth. But because of all the meeting requirements, it just doesn't work. So it falls back on Matt.
Vince's comment, I think, is very prescient and very important, because many years ago, when I spoke to our previous council, who's now the counsel for the city, and I said, oh, I'm sorry, and the particular applicant was making a presentation, and at that point, since it was a public meeting, but it was strictly a concept review, I made several observations, because clearly the applicant didn't know what he was doing. And afterwards, I gave as much as I could say in a public environment, and I spoke to our legal counsel, and I said, this person desperately needs help. And we could shortchange that process terrifically if I could talk to him. And I was advised, you absolutely cannot. You have to do everything here. And it was unfortunate, because there was technical knowledge that the applicant absolutely did not have, and it was technical knowledge that I have, and they could have gotten all that information for free. Instead, the applicant had to go out and spend actually hundreds of thousands of dollars for things that he could have gotten for free. But to your point, Vince, FOIA, we're bound, can't talk to them, can't say a thing.
Right, but FOIA is what it is, but this discussion, I think, is quite helpful. I'm not sure whether we're going to get all of this drafted by,
No, in fact,
but we might get much of it, and we might be able to discuss some of it, but not discuss some of it. But and again, I'm just putting it out there so I get direction from all of you. But if project concept review is going to be mandatory, then that might be the right moment, it seems to me, for this body in a public session to exercise whatever discretion it wants to accord to itself, with the blessing of the Board of Commissioners, to say, no, that's not really what we meant.
Should this project go forward? Do
Yes.
we need to have this project going forward to finish all of these time-consuming and costly steps to get a final site plan approval, or just cut it off at concept review?
Now, in the past, when we've included some discretionary language for this body, you wanted to put as much concrete indicia in the language to guide the exercise of your discretion. Does that remain the case for this issue? That is, do you want to have unbridled discretion, or do you want to define the parameters of your discretion to kick back a project that you think, well, it's not what we intended, it's not what the code intended, we don't really need to conduct a site plan review?
Built into 236-30A, these categories of projects for which site plan review, the full site plan review process would be applicable and required. So that's the presumption when somebody shows up for concept review. They're there because under 236-30A, they fall into one of these categories. So there should be a presumption that we complete the process, but if during concept review, for whatever reason, a case can be made that it's not worth the applicant's time and money, or our time and the city's resources, to continue that process all the way through, then perhaps some discretion on our part to cut it off at concept review might be appropriate.
No, I understand that. My question was more, as I draft this, do you want sort of within that context simply that discretion, or do you want to attach, certain objective indicia that would guide the exercise of your discretion? I think the answer probably is no.
Like we did in the
Like we did on
preliminary review.
like we did there.
Language.
Yes, like we did there. But
I
I think this might be different.
I think free expression would be, I'm not talking about giving my opinion on something. I mean, an applicant may come in here and go through structurally a whole bunch of things and say that they're going to decorate it in goth. Well, peace be with you. I wouldn't do that. That's irrelevant. That's an opinion. But when it's facts of science and engineering, you can indicate to the applicant, well, gee, you wanted to do that, but I'm sorry, you're doing that in the beach block, and because of liquefaction, you actually can't do a foundation like that. You need to do it by Y. It at least gives them guidance to get to the point where they can ask more intelligent questions when they go forward. If they're going and not asking intelligent questions when they go seek guidance, then it leads to more cycles with us. When they come in with plans and they just spend a whole bunch of money and they say, well, this is what we're doing, and then they get upset because, well, no, you really can't do that. And here's the science why you can't do that. It's not a function of my opinion. But that applies to everyone here. Is we have architects, lawyers, attorneys, environmental. So we bring other knowledge that who they're dealing with may not even know, but yet we know naturally because of our years of experience. So I was really looking at it from that standpoint to be beneficial for the applicant, to help, to some degree, really address what Vince was saying, help shorten their whole process indirectly, and in fact may save them a lot of money and effort and time if they have better guidance at the front end.
Yes, Mr. Stockdale.
May I ask one question, and it may go to past practice more than anything. When we're talking about big projects, little projects, what we look at, what we don't look at, going to the definition of substantial renovation, when we talk about reconstruction of 25% of the floor area, what meaning is given to the word reconstruction? In other words, if someone wanted to resurface an existing floor, change hardwood to tile, is that reconstruction?
No, that is not reconstruction. That would just be, again, resurfacing. Reconstruction would be removing the structural members, reapplying floor joists. Let's say you discovered you had some rotted floor joist in that.
And that's a settled understanding, that's the way it's been read?
It is.
Okay, thank you.
Would not have gotten caught up in
Yeah,
this.
that's
Sounds like
because it seems to me we've narrowed,
Yeah.
the the field of uncertainty here, if you will, by a lot of the changes we
Ms.
made.
Davis, just a question.
So back to discretion. Is that, or we're past it? We passed discretion? Were you asking whether
I
you're
think,
gonna?
I think I'm gonna draft it in such a way that gives you sort of discretion subject to the language of 23630A and not try to confine your discretion, because I think that'll be an exercise of futility.
Ms. Davis, would you want to have this body's right to stop a review only in the concept review phase? I mean, that's what I'm hearing, I think, but I think we need to give,
That's certainly what I suggested.
okay, because I think we need to give Luke that, we need to give Luke that
Because
direction.
if the project meets the definition of one of the subcategories of 23630A, and if there are still issues after a full-blown concept review that need to be resolved, that we think the site plan review process should continue, then it should continue. But if after listening to it, and if it were a project where, yes, it met the substantial reconstruction or renovation terms, but when we found out more facts and circumstances, nothing else was changing, you know, the FAR, the height, all of the standards, footprint, everything was going to be the same at the end of the day. And for whatever additional reasons, we thought that it didn't make sense to continue on through, then we could cut it off and let the applicant go home and get his building permit.
Okay. Given where we are and given the fact that we have 2 meetings back to back, thank you, Mike Bryan. Not sure of the wisdom of that. But I'm wondering if we might give Mr. Mehta a little longer to do a draft to circulate to us so that we then, at the December meeting, have plenty of time to review in advance, formulate what questions we think exist, and basically give him a night off.
Well, he's got the report to write.
Yeah, he doesn't get that.
But
Yeah,
yes.
that's right.
But he can stop at midnight now instead of 2 a.m.
So if that's all right, we'll put this on for the December meeting.
Yeah, sure.
As opposed to
Appreciate
bumping
that.
Vince and his
Yeah.
application tomorrow.
I mean,
Yes, that's right.
Especially
I
because.
said as opposed to bumping you another month.
Especially because part of the drafting will rely on a submission from Ann.
Right.
Okay.
I think
Could,
that's the way to do it.
could I just say one thing? Because I really appreciate the interaction between Earl and just the sort of building inspector's office with regard, and Commissioner Stewart as well. I mean, I would hate for there to have been so much confusion from this meeting that someone thought that resurfacing from tile to wood or vice versa meant that they now, because of these new terms, would have to go through concept review. And I think with all the back and forth, with all the different examples being thrown around, that unfortunately, could be or could be made to be a public perception. So I think it's very important to retain the clarity that these amendments go to better capturing larger projects that we haven't seen before, and that we're not extending any regulatory reach into smaller projects that we haven't seen before and don't want to see now. So I just think that was actually an excellent example of how just the term reconstruction actually makes sense and would not be applied in a way that would capture something like the resurfacing of a floor. Because it's very easy, I think, in the context of all this discussion, which is very good discussion, and but it goes, so we've brought up a lot of different contexts and examples, and we don't want the public to feel like that they are under these new regulatory burdens when in fact they are not.
Agreed.
I don't know if that means we're going to have a new definition for reconstruction.
Well, no, I think I think
We have substantial reconstruction there, but we don't define reconstruction. We have substantial renovation, but we don't define reconstruction.
but the definition of substantial renovation includes the term reconstruction.
Reconstruction, which might also need to be defined, is all I'm saying.
No.
Well,
So that
Yes,
so
although-
that it's clear it doesn't include resurfacing.
I want to thank you, Mr. Janis, for helping us with this. And
Yeah,
I kind of wish we had been able to utilize this earlier. But
Thank
I
you, ma'am.
think I'm glad we've come to the point where this dialogue is very productive and healthy.
Always available to you.
Yeah.
All right. Members, see you tomorrow. We're adjourned.
And you just about got us to 4:30 too.
Mics are on.
Good.